Good afternoon, everyone. It's great to be with you again. It's June 28th, and I'm here in New York City in Midtown looking out. It is bright and sunny and is certainly beginning to feel like summer here. And it is a very busy time with lots to share with you. And so I'm looking forward to catching you up. So Kathy, if you'd advance to the next slide, I'll walk everyone through today's agenda. I'll start with our typical update on where things stand with COVID. I'm going to also move into a brief recap of all of the Supreme Court activity. And then David Ferrara, who's with us, will talk about some of the workplace implications, particularly around the Dobbs case, which of course involved Roe. Then Sandra Casey will speak about Title IX and a notice of proposed rulemaking. We'll move to Teresa Schoeneck, who's going to talk about non-discrimination standards in the context of the EEOC. Brody Smith will touch on zoning and land use updates, and we'll save some time at the end, ideally, to take your questions. And with that, Kathy, if you go to the next slide, I will start our updates. So in terms of COVID, we are unfortunately seeing some creep back in terms of numbers. Nothing huge yet nationally, but there's a 14-day change rate of 1% based on these data. And what we're seeing really is that there isn't that kind of seasonality everyone had hoped for with COVID, where it's like the flu and it's worse in the winter and it improves in the summer. That's not really been the pattern with COVID as we've moved into this latter stage of it. And so we'll have to watch these trends over the course of the summer, but it's important just to know in terms of numbers of cases specifically, that's distinct from hospitalizations and deaths, but the number of cases, it's remaining pretty fixed. Next slide, please. What you'll see is that here, the hotspots have changed a bit from week to week. Back on June 14th, when I was last here to host, there was a big concentration, particularly in the western corner of the United States around California, particularly where things were creeping up. That's still there and arguably has gotten even more concentrated. What we're seeing as well is a wider spread throughout the Southeast and in Florida. So that's consistent with what we're seeing. The numbers aren't dropping. We're just seeing movements in where the points of concentration are around the country. Next slide, please. Here in New York State, we are seeing some ticking upward, unfortunately. The numbers are still pretty low as compared with some of the worst moments that we've seen recently, including the first Omicron peak back at the turn of the new year. But we are seeing about a 17% rise since the last time I was with you 2 weeks ago. Again, here in New York State specifically. There are no new mandates, whether federal, state, or local, to report out. The recommendations on indoor masking remain in place. The one big development since I last was with you was that on vaccinations, kids who are as between 6 months and 5 years old now can get either Pfizer or Moderna, It's been approved. And so I know that there are families considering those choices right now. And that is the big difference since last we spoke. Next slide, please. In terms of New York, as I mentioned, the overall is about a 17% bump upward. And you'll see here on this slide some of the differences in the various geographies around the state. And in Rockland in particular, just north of the city, you're seeing a pretty significant uptick as well. Ontario, it's a smaller number overall, but it's worth noting that it's also going way up. Let's go to the next slide, please, Kathy. I'm going to switch gears now and talk about the Supreme Court activities. And here, what I'm going to do is just quickly highlight some of the key cases that have come through over the last couple of weeks. There are many more that didn't make this slide. And it's important to note that here at Bond, we're here to report information. There obviously are strong feelings about a lot of these decisions and lots of unfurling political consequences around it, but that's not for today. What we're here to talk about is essentially, what has changed and how it will affect various aspects of your businesses, your operations, all of which we're tracking very closely. So on reproductive rights, of course, there's Dobbs, which unwound Roe. And then with the Second Amendment and guns in mind, we saw the New York State Rifle Association, the NRA, excuse me, with the concealed carry victory there that overturned what was about 100 years of precedent in New York law. And I'll get to what the New York State reaction to that is momentarily. On matters of religion, 3 different cases worth raising. The first being, we're looking at one that essentially invalidated a way in which the state of Maine was distinguishing funding for religious institutions when it came to a state tuition program. That the court has said by 6-3 is not okay. There's also an affirmation of a constitutional right to pray in the context of sporting events, also in the scholastic contest. The specific facts there, involved a coach at the 50-yard line in the game of football. And so then finally, where there was much more unanimity, if you look at the last, Shurtleff versus the city of Boston, essentially Boston was errantly, according to the court, making a decision to exclude the opportunity to raise a flag with essentially ways that denote Christian values, when it had provided other groups the opportunity to raise its flags on city property. And so the court said that wasn't okay. Again, nothing that I'm here to describe is intended to get into the depth of these decisions, but we're just giving you a flavor of some of the really monumental changes that came out of the court in these last few weeks. Next slide, please. In New York State, what we're seeing is a specific reaction by the governor. Governor Hochul has called an extraordinary session, and it's to convene later on Thursday this week, and it will involve gun safety. And there's a context, of course. Today is primary day in New York State, and here's my pen. I went to vote earlier today with my wife and our son. It is an important moment for those making or essentially seeking office in New York State, both on the Democratic and Republican lines. This is also, though, not a day where we're doing anything in the realm of federal primaries. That's in August, as I had summarized for you in a previous presentation. So with that, let me move to the next slide, please, because I'd like to introduce David Ferrara, who's with us, to get a little deeper on some of the Supreme Court activity. And David's going to tell us in specific what to think about in the workplace context now that Roe is no longer the law. And before we do that, I just want to make sure all of you know that Dave represents both private and public employers in a variety of matters, including before the NLRB and the Public Employee Relations Board, labor arbitrations, union organizing campaigns, conflict resolution. And he has a really wide-ranging practice that includes manufacturers, municipalities, school districts. I could go on, but let me give Dave the time to catch all of you up. Dave, thank you for taking this moment to be with us, and the floor is yours.
Gabe, thanks very much. And folks, thank you so much. Great to be with you here again. As many of you know, I've been working out of the Syracuse office for a little over 30 years, long enough to remember some disputes and some conflict discussions or controversial discussions when Roe versus Wade was passed. But I'm happy to say I happened to be graduating from high school at that time and not practicing law. On a serious note, Bond greatly appreciates your participation today, and we highly value the longstanding partner relationships we have with many of you and your firms. So I just want to reach out to thank you sincerely for your continued participation. Kathy, let's just talk a little bit about the next slide. Obviously, Dobbs versus Jackson Women's Health is going to create inevitable confrontation among coworkers, supervisors, and managers, and even spill over into potential customers, vendors, as we know, these type of highly charged political situations and social issues can oftentimes impact our customers. Very few political issues in the past 50 years are going to carry the same degree of emotion as the court's decision is in this Dobbs case. When you have religious and women's health concerns front and center, you can't help but have a significant emotional impact. Next slide, please, Kathy. There'll also be, of course, economic implications of unwanted pregnancies, and the pressures that that's going to put on certain families will add to this uncertainty. I do believe it is a powder keg, like so many other social and political issues. Where do they end up? They end up in the human resource professionals' lap, and how to deal with it and how to guide their entity through some of these very difficult times. I think you'll see off-duty protesting activity on both sides of this argument likely spill back to the workplace, which, you know, as we've talked on prior sessions, then it becomes our problem, right? Then we definitely have to address it. I don't think you can rule out workplace violence, unfortunately. Again, I'm dating myself, but going back to the many episodes that have happened in abortion clinics or in religious organizations from an anti-abortion perspective, this is going to have long-lasting consequences for many of you and for many of your employees. Next slide, please. So what should you do, and what are the challenges you're going to face? Well, a lot of common sense here. Be proactive. Send the right message to the organization from the top as soon as you can. You need to know what is your message. Your employees are going to want to know. And it may be very neutral, but you need to internalize what's the right message. Next, review and update your policies. And I'm talking a broad spectrum of policies, from clothing, harassment, parking lot rules, lockers, desks, relocation. You might wonder why relocation, right? There's going to be a number of employees that are going to want to pursue the right, their right in their mind to have an abortion, even though the federal government or the Supreme Court has now changed that at the federal level. But again, just for perspective, this simply means the states are going to be left to regulate what can and can't happen in this area. So it doesn't mean abortions are going to go away. Clothing, when someone comes in with the t-shirt with a baby on the front and maybe in some compromised position because of their anti-abortion position, or vice versa, people wearing buttons and bumper stickers out in the car, in your parking lot. All of this is going to create conflict and friction, unfortunately, for you to deal with. Next slide, please. So establish boundaries. Make sure from a political expression perspective, not just abortion, generally including abortion, but many other social issues, you should look at your internal policy to assess what you've expressed and what you've decided are going to be the boundaries of what you're going to permit in the workplace. Remember, at the end of the day, any of this that has a disruptive effect on your workforce or on your workplace or on your customers, that becomes the area in which you should and need to manage and manage proactively. As I said earlier, the next bullet, define the company's position. Leaves of absence. Are we going to continue to provide leaves? How about our health insurance plan? For those of you that have insured plans, remember the states regulate insured versus self-insured plans. There are 11 states currently that are seeking to ban abortion through regulating your insured health plan, okay? Financial assistance to travel to other states where abortions are legalized. Some of the big companies, Disney, Facebook, JP Morgan, have already come out publicly that they're going to continue to provide financial assistance. And some have increased the financial assistance available for individuals looking to move to or to travel to another state to find and be able to procure an abortion. What's the legal landscape look like? This might come a little bit as a surprise, but generally there is no current federal or state prohibition against discrimination based on an employee's political expression in the private sector. We don't have time to dive into the nuances of the public sector reign, where obviously free speech and the constitutional rights become more at play. But from a Title VII perspective, and for those of you that are here in New York, from a New York human rights law, this is yet not a protected class. I underline yet because, as we know, anyone who's lived in this HR world over the last 15 years or so know that protected categories keep and continuously get added. However, please note, there is discrimination, obviously protection based on religion and creed. And Title VII is confined to religion, creed, but there's going to be many arguments that anti-abortion views are based on a fundamental religious belief. And we know what we just went through with COVID, how loosely the courts have defined what is a fundamental religious belief. So I do think we're going to see challenges there. From New York's perspective, you may remember 201D of the labor law prohibits discrimination based on off-duty recreational activities, smoking pot, sports activities, or engaging in political activities. As long as, next slide, please, as long as those activities occur outside of working hours, off premises, and without the use of company equipment. Historically, political activities have been interpreted very narrowly, campaigning for candidates or fundraising, not covering expression of political views. So it remains to be seen, what will a court do with respect to bumper stickers, posters? Does that activity rise to the level of campaigning? I'm only aware of this one case, this cold case, where the court said it is not broad enough, picketing and protesting over a social issue does not fall within the rubric of recreational activity. I'm not aware of any other cases to that extent. Yesterday, I saw the IBM CEO made a statement publicly that employees, he believes, will gravitate to companies to share their perspective and willing to help employees. So you're going to want to take that into consideration. There are companies who didn't do it right in the beginning. 2 years ago, Disney had a huge issue with the LGBTQ community and the state of Florida. Coca-Cola had an issue with voting rights in Georgia. They went public and had a tremendous outcry from their employees. And of course, Starbucks' position on Black Lives Matter was just off on the wrong foot from day one. They've obviously learned their lesson because their prohibition on wearing anything that supported Black Lives Matter created tremendous issues, and quickly was reversed. And now they're at the front and center of providing transportation aid for people engaged in seeking an abortion outside the company. So moving forward, whether you decide to publicize your position, that's an employer specific issue. What's most important, you need to know what your position is early versus late. Employees are going to ask, they expect to hear from the company in some form or another. Finally, if I might, what's next? I think we're going to see plenty of litigation from states seeking to ban abortions. We already have 26 states that currently prohibit it. I believe you'll see civil penalties. Texas, Oklahoma has aiding and abetting language for civil action can be brought against an employer who aids or abets those having an abortion. And I think you will see challenges under 201D for potential discrimination based on gender, pregnancy, religion, and potentially political expression. Lastly, those of you in a union environment, the NLRB most likely is going to take up this issue. Is protesting concerted and protected? If it is, then you're not free to sub-discipline those individuals or terminate for misconduct. So there's going to be a balancing act that you're going to have to look at very carefully. And I can see some unions looking to use this as a rallying cry. If you're not providing benefits for women in connection with abortion, might you see organizing campaigns based on that premise? Obviously, a great deal of uncertainty for sure. Thank you very much for your participation.
And thank you, Dave, for what was a very thorough presentation. We could, of course, gone far more deeply, but it gave everyone a good flavor of what some of the workplace dynamics may well look like as we move forward with life after this Dobbs determination. I want to quickly turn to Sandra Casey, who's senior counsel in our Albany office, who's a very distinguished, previously serving general counsel with SUNY, as well as college counsel at Siena College, and has much to share with us about Title IX. And rather than taking more time to introduce Sandra, let me allow you please to get to your remarks. It's an important time in the Title IX universe as well. And we want to all hear more. So thank you. The floor is yours.
Thank you, Gabe. And thank you for allowing me to speak on the Department of Education, the U.S. Department of Education's unveiling of draft proposed rules under Title IX. And the Department of Education issued these or released these proposed rules on the 50th anniversary of the enactment of Title IX, which was appropriate. And these proposed rules actually make sweeping changes to the Title IX regulatory scheme that went into effect just 2 years ago. And I've put in a link to the proposed rules. But it's important to keep in mind, again, these are proposed rules and they actually have not yet been published in the Federal Register. So the comment period has actually not started yet, the 60-day comment period. So the comment period will begin once those rules are proposed in the Register, and the department will have to sift through many comments after the comment period ends. So it may be many months before we see final rules, but colleges and universities are, encouraged to look at the proposed rules because we don't think that they're going to change that much once they become finalized. This is because the department actually engaged in a year-long process of listening to Title IX stakeholders and advocacy groups, and they took all the comments into consideration when they drafted the proposed rules. Next slide, please. So the department issued a fact sheet. If you don't want to read through the 700 pages that are included in the proposed rules, there's actually 50 pages of actual proposed regulations and then 650 pages of commentary. But you can get a quick fact sheet by going to this site that I have put in the presentation. So the department makes clear that sex discrimination under Title IX includes discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. So they've expanded what sex discrimination means. They added in pregnancy, and that's notable. Pregnancy or related conditions mean pregnancy, childbirth, termination of pregnancy, or lactation. Next slide, please. The proposed rules provide a new definition of hostile work environment, hostile environment harassment that includes severe or pervasive conduct that denies or limits a person's ability to participate in or benefit from a college or university's program or activity. Rather than severe and pervasive under the current rules, it's severe or pervasive, so it's broader. The proposal provides a new definition of supportive measures that specifically includes temporary measures that burden a respondent in a complaint's in position for non-punitive and non-disciplinary reasons. So in other words, you can burden a respondent if it's not considered punitive or disciplinary before a final resolution has occurred. The rules also eliminate the distinction between directly related evidence and relevant evidence. People who have done Title IX investigations know that there is this whole rubric that has to be followed with regard to directly related evidence and what needs to be shared to the parties, and that what needs to be given or provided at the hearing, which is relevant evidence, and you can exclude directly related evidence. So it's very complicated right now. So the department really streamlined everything in these proposed rules, and they just talk about relevant evidence, and that is a definition that's related to the allegations of sex discrimination under investigation, and questions are relevant when they seek evidence that may aid in showing whether the alleged sex discrimination occurred, and evidence is relevant when it may aid a decision maker in determining whether the alleged sex discrimination occurred. So much easier to follow. Next slide, please. The proposed Proposed rules expand the current application of Title IX regulations to the proposed rules obligate any sex-based harassment contributing to the hostile environment occurred outside an institution's education program or activity or outside the United States. Specifically, Title IX would apply to any conduct that is subject to the institution's disciplinary authority. Next slide, please. The proposed rules would greatly expand mandatory reporting and related obligations of most personnel on college and university campuses. Under current regs, employees who are not confidential resources and who have authority to institute corrective measures would be required to notify the Title IX coordinator when they receive information about sex discrimination conduct. The proposed rules state that an institution employee who is not a confidential resource and who has responsibility for administrative leadership, teaching, or advising would similarly become a mandated reporter of such conduct impacting students, which would appear to include most faculty. All other employees who are not confidential resources would be obligated to either report such information to the Title IX coordinator or alternatively provide the Title IX coordinator's contact information and information about reporting options to the reporting party. So it's really all hands on deck when it comes to conduct that would violate Title IX. Next slide, please. Under the proposed rules, the standard for emergency removal of students from campus pending of an outcome of a Title IX grievance process is different from current regulations, which allow removal where their continued presence of a student poses an immediate threat to the physical health or safety of the reporting party or others. Under the new rules or the proposed rules, emergency removal would be authorized in cases involving an immediate and serious threat to the health or safety of such individuals. So it really permits emergency removal based on threats of emotional harm. You don't have to show physical threat. Next slide, please. Generally, the proposed rules bring back, that flexibility that campuses had to investigate and resolve a claim of a Title IX violation. The proposed rules eliminate the strict time requirements under the current regulations and instead require that institutions complete the major steps of their processes in prompt time frames. Next slide, please. There would be no requirement that institutions conduct live hearings at which each party's advisor may cross-examine the other party and any witnesses. Institutions would be permitted to continue live hearing systems, but would also have the option to return to a single investigator model or a hybrid model not involving a live hearing. If these alternative models are implemented, institutions would still be obligated to ensure they incorporate processes to evaluate credibility of parties and witnesses and give parties an opportunity to review an investigative report and or all relevant evidence. Thank you. Next slide. So if an institution chooses to use a live hearing model, they could either allow each party's advisor to cross-examine the other party as is required under current regs, or they can allow each party to propose to the decision maker questions to ask the other party and any witnesses. It's also important to note here that some case law in other jurisdictions may impose additional requirements on Title IX grievance processes. So institutions definitely should consult an attorney in determining what model should be used in accordance with the proposed rules once they become finalized. Next slide, please. Like the current regulation, the proposed rules require institutions to address retaliation against parties or witnesses. Currently, campuses have the ability to use any process or practice to address retaliation complaints, but under the proposed rules, they will be required to use the Title IX grievance process. And also, schools will have an obligation to address peer retaliation, such as student-on-student conduct. Next slide, please. And then there's just miscellaneous things that the proposed rules kept consistent with the current regulations, the party's right to utilize an advisor, the presumption that a respondent in a complaint is not responsible unless a finding of responsibility is made through the title grievance process, an obligation to post training materials on institutional websites, broad authorization for the use of informal resolution processes, and standards for appeals of determinations and dismissal of complaints. Next slide, please. So in conclusion, I would just like to state that even though these are proposed rules, they haven't been published yet in the Federal Register, schools are encouraged to look at the requirements now, to contemplate any changes to their policies and procedures, and take the opportunity to enjoy the flexibility that the proposed rules afford in order to better align with institutional culture and practices. And with that, Gabe, I am finished, and thank you for allowing me to highlight these draft regulations.
Very much appreciate your time, Sandra, and thank you for all you walked through here. There was already interest expressed in the chat to see some materials and follow-up, so clearly this was a well-timed presentation. And let me now turn the floor over to Teresa Rusnak, who's an associate out of our Rochester office, and she's going to be speaking about the EEOC and non-discrimination matters. It's important that you just know for background that she has been acknowledged as one of the best lawyers in America in upstate and an upstate New York super lawyer rising star, among other accolades. And that puts her in good position to walk you through this material. And the floor is yours. Thank you in advance for your presentation.
All right, thanks, Gabe, and hi, everyone. As Gabe said, I will be talking about some EEOC updates and just broader non-discrimination terms for people in the LGBTQ community. So, Kathy, if I could have the first slide. So what prompted this presentation was two things. It's the end of Pride Month, so it's timely in that way. And also yesterday, the EEOC announced that it added X as a gender marker for its forms. So on June 27th, the EEOC said it had added an option for complainants, so those submitting an EEOC complaint, to select a non-binary X gender marker during the intake process for filing a charge for discrimination. The EEOC also said that it's modified its charge of discrimination form to include mix in the list of prefix options. So that was the EEOC following through on an announcement it had made earlier in March, and further evidencing the agency's intent to be gender neutral, and certainly to likely stand behind complainants that are and that bring claims on that basis. To find out more about the LGBTQ plus community and discrimination from the EEOC's perspective, I've listed the web address where you can go and learn more about that. Next slide, Kathy. I wanted to catch us all up on where we are in terms of gender identity and sexual orientation, discrimination, and harassment right now in America. And I'm going to start on the federal side of things. So in 2020, just about 2 years ago, because it was in June, the Supreme Court held in the Bostock line of decisions that Title VII protects gender identity and sexual orientation because they're connected to sex. So for the first time, we had the federal government saying that Title VII, which has long protected sex, age, race, other types of protected categories, is now also going to protect gender identity and sexual orientation because those two things are connected to sex. And I have one of the quotes from the court there that you can read at your leisure, but basically saying that we have protected sex and gender identity and sexual orientation are inextricably a part of that. And so they also must be protected under Title VII. Next slide, please. So what does that mean? Following that decision, employees who believe they've been discriminated against, retaliated against, or harassed based on their sexual orientation or gender identity can now bring their claims in federal court. Claims under Title VII, if successful, can involve back pay to the individual if they were terminated or suspended without pay, compensatory damages for emotional distress, which can range up to $300,000, punitive damages for particularly egregious conduct. And of course, employees have about 300 calendar days in most states from the last act of discrimination to file a charge with the EEOC. Next slide. On the New York State side of things, we have GENDA, the Gender Expression Non-Discrimination Act, which was passed in 2019. It amends the New York State Human Rights Law by adding gender identity or expression as a protected category. The law defines it as a person's actual or perceived gender-related identity, appearance, behavior, expression, or other gender-related characteristic, regardless of the sex assigned to that person at birth, including but not limited to the status of being transgender. So essentially, it protects the way a person expresses gender through speech, dress, and behavior while in New York State workplaces. Next slide, please. So I'm going to go through quickly 3 slides where I tend to see employers have the most questions. And the first one is on pronoun use. So in New York State, and now very possibly under Title VII and federal law as well, failure to use correct pronouns for individuals in the workplace is a discriminatory and harassing act. As a reminder, correct pronouns may include they, them, he, him, she, her, ze, them, and there's a whole lot of other pronouns that I didn't have the time or room to include in this slide. So please remember to use the pronouns that people use for themselves and that they ask you to use for them. Failure to do so may and very likely will be harassment or discrimination. I've just included for New York City purposes, they've explicitly released guidance that said if you use incorrect pronouns and it rises to the level of severe and pervasive harassment, your penalties can be very high, ranging into the multiple 6-figure. Next slide, please, Kathy. Another area I get a lot of questions about is restrooms and gender identity. I know there's been a number of states that a couple of years ago passed laws on this, and there's been some debate about this, but for New York State purposes, I can tell you that transgender and gender expansive employees must be provided access to facilities, including restrooms, locker rooms, and or changing rooms consistent with their gender identity as asserted at work. Employees cannot be required to use a single gender facility that conflicts with the person's gender identity as asserted in the workplace. And employers are also required to provide reasonable alternative arrangements for any employee who expresses a need or desire for increased privacy related to their gender identity. So that's certainly the law in New York State. It's a little less clear on the federal side of things, whether this would amount to discrimination or harassment post-Bostock, but it's certainly possible. Next slide, please. And then finally, question I get quite a bit is about religious considerations and how that intersects with people's gender identity and how people express their gender identity in the workplace. As we know, the New York State human rights law, as well as the New York City law and Title VII, prevent discrimination on the basis of an employee's religion. So your employer can't terminate you because you have particular religious beliefs. But in this context, an employer's actual or perceived religious objections do not justify discrimination, nor do a coworker's beliefs justify the same. So this was actually part of the Bostock Supreme Court decision. They said that very clearly, because even though the employer was of the religious belief that he couldn't have a trans person working for him, that was not enough to justify the actual discrimination that took place. So essentially, it is not a violation of an employee's religious rights in the workplace to require that person to follow the law, which in this case would be to use the correct pronouns and allow access to the appropriate restroom and other types of facilities for someone based on their gender identity. I will note at the bottom there, for religious institutions, Title VII does not apply to employees in ministerial positions. So if you are in the religious institution category, I encourage you to consult with counsel on these particular areas. And Gabe, with that, I am done.
Thank you so much. And I so appreciate your presentation. It is well timed, as you noted, especially with yesterday's word from the EEOC. And now what we'll do is give Brody the floor. Brody Smith comes to us as a member in our Syracuse office with a practice that involves environmental law, eminent domain, real property, and a whole lot more. And he's going to be speaking about zoning and land use, giving us an introduction to areas that a number of us just could learn more about. And so Brody, the floor is yours, and looking forward to learning along with you.
Okay, I do feel like my presentation is a little bit of a change of pace. It doesn't have any employment or labor update aspect to it, but the good news is it affects every single person or every single business, either already has or will in the future, because we're all sitting in buildings that at some point have gone through the land use process for approvals and permitting. So just jumping right into it, the general scheme in New York for zoning and land use approvals I'm going to talk to you a little bit about what zoning is, a little bit about what variances are, special permits, and site plan approval. So slide. The common zoning scheme for any municipality, be it a city or a town or a village, involves a comprehensive plan. A comprehensive plan is an aspirational document. So if you ever have reason to look at those, it won't look like a regulation or a statute. It talks about, gives general information about a municipality, and then it provides guidance to the lawmakers who eventually draw the zoning. You'll see a zoning code, which is a much more formulaic document that talks about where certain uses are permitted and how they have to be approved. There'll be a planning board, which is an appointed board that, generally speaking, will give approvals for site plan approval, for special permits. That's a lot of the nuts and bolts of ingress, egress, screening, parking, that sort of thing. And then there's a separate appointed body, which is called the Zoning Board of Appeals. They deal with the variances, or if you have a dispute with the codes officer or the planning office and you want to appeal some decision, you can take that to the Zoning Board of Appeals, and that is a quasi-judicial body that can then adjudicate that dispute. Slide. So zoning, what is zoning? Almost all of the United States has something called Euclidean zoning. Euclid was a mathematician in ancient Greece, sometimes known as Euclid of Alexandria, the father of geometry, and a lot of people believe that Euclidean zoning is based on him. Slide. It is not. Euclid is actually a village which is a suburb of Cleveland, so not nearly so auspicious of a beginning. But this is where you see the beginnings of zoning in the United States. Euclid, the village of Euclid was on the outskirts of Cleveland during the late 1800s and the early 1900s, when Cleveland was experiencing explosive growth. So industrial development was expanding towards this village and threatened to swallow it up. The village of Euclid wanted to assert their independence, and they created the first zoning map, the first zoning code, and tried to limit industrial development to certain portions of the village and have other portions be only permissible development to be residential and commercial development. Slide. So Euclid v. Amber Realty happened in 1926. Basically the issue before the Supreme Court was police power of a village to determine its own course in terms of land use and development, whether it was a taking, because by virtue of zoning land, you're limiting the possible uses. So are you taking something from the property owner that then needs to be compensated? And eventually the Supreme Court dealt with all those issues. Slide. What's a taking? A taking is where the government takes property or the right to engage in certain business activities from an entity or a person without properly compensating them. In this case, it was a significant change. Without the zoning, where the land was very desirable for industrial development, it had a value over $10,000 per acre. By virtue of the restrictions, the land was then worth only a quarter of that. Slide. What's police power? Well, it's from New York City to the tiniest town in upstate New York. Every single municipality has police power to protect the health, welfare, and of the public within its jurisdiction. And so the Supreme Court had to evaluate whether or not that the creation of zoning was a proper use of that police power. Slide. The most memorable visual from that decision was the pig in the parlor example. And the Supreme Court said a nuisance may merely be a right thing in the wrong place, like a pig of a parlor instead of a barnyard. If the validity of the legislative classification for zoning purposes is fairly debatable, the legislative judgment must be allowed to control. Slide. So the holding in the end was that the court decided that the municipality did have the right to assert its police power and create this zoning scheme. They said that they didn't go beyond a reasonable exercise of that power, that their goals were not arbitrary and capricious. And from then on, zoning spread across the entire nation. Slide. So this is the city of Euclid zoning map. It hasn't changed that much since 1926. The blue swath in the middle is industrial, industry, warehouses, manufacturing. On the northern part of that swath, it's residential, with commercial in between on the main arteries. Slide. You see that affected the development. It's evident from an aerial photograph. There's one place to live, one place to work, and one place to shop, and they're different places. Slide. This is an actual aerial from Euclid. This more than anything else in our society created the suburban sprawl, the sort of car culture, that we live within. And, that concept of Euclidean zoning is the seed of that. Slide. There's other kinds of zoning, and it's important to be aware of that because many municipalities are trying to try other things. One example that was recently enacted within the last couple of years is the Buffalo Green Code. It provided a framework that completely abandoned Euclidean zoning and led to the development of a new form-based approach to zoning. Slide. They call the actual code the Unified Development Ordinance. And when they talk about form-based zoning, the idea is it emphasizes the character of a neighborhood as the organizing principle, rather than dictating what uses are required in certain areas. There is a assumption that certain forms of development are desirable or fit in a certain place, and whatever the use may be inside that building, so long as it doesn't have nuisance-like impacts, the municipality is not going to go and micromanage uses. So if a business switched, took on a new lease and completely switched from a pharmaceutical manufacturer, to office space, so long as the exterior of the building didn't change in a form-based zoning, there may not be a need to go back for the planning commission. Slide. So what that looks like is you have this code that dictates certain types of buildings in certain areas. So the zones become not about use, but about building configurations and types. Slide. For example, on that page I just showed you, that's one area of Buffalo. They listed a number of different buildings that are permissible. One of those is an attached house. So if you blow up that section of the green code, you see there's a definition of what an attached house is. It gives certain requirements of what the frontage elements of it would be. In this case, arcade, forecourt, plaza, awnings, balconies, porches, stoops, that sort of thing. Slide. There's rules still about height and width, bulk requirements. There's also rules about transparency. It's been determined by planners who study this issue. And as you might have gathered, one of the purposes of form-based zoning is to increase walkability, mixed-use development, that sort of development. And to encourage that sort of thing, planners have found that having a lot of windows with people living and working behind those windows make people more comfortable walking in a neighborhood than just a bunch of blank walls where they're not seen and can't see other people. So there's requirements about transparency for different areas to encourage pedestrian access and pedestrians feeling comfortable. Slide. What if you don't fit the code? Whichever sort of zoning it is, whether it's form-based zoning or Euclidean zoning, if you don't fit the use, you can apply for a use variance. The use variances are generally difficult to get. They have a 4-part test wherever you are in the state that is difficult to meet and more or less requires you to prove that you can't get a reasonable return on your investment under the current zoning. Slide. The toughest part of that test is to provide competent financial evidence that it's not the property cannot be profitable under the current zoning. Slide. So an example, a school building. We got a use variance on a school building that was converted to multifamily residential. It was zoned single family residential. It was not economically feasible to make a 6,000, a 60,000 square foot school building into a single family residence, you're able to provide that evidence and get a use variance slide. Area variances are much easier to get. They're variances from bulk requirements, height, side yard setbacks, front yard setbacks, and the 5-part test that's applied for those is much more permissive. And that's something that you're much more likely to be able to get some relief from. And I'll stop there. You've learned a little bit about zoning, the alternatives to zoning, and one of the ways that you can get relief from zoning requirements that are not, don't fit with your business through variances. And I'll stop there. Thanks, Gabe.
Thank you, Brody. That was really informative. We appreciate it. All I know we're a bit over time. We thank you for sticking with us. The contact information for the attorneys you heard from today is up on the slide that Kathy has put on the screen. You can reach out to any of us or your preferred bond attorney if you have questions that come from today's session. And I will be back with you in 2 weeks' time. Adam will be with you on July 5th. Have a terrific holiday weekend, a meaningful one, and wishing you all safety and a terrific afternoon as well. Thanks.